re-examination can only happen if the witness has been cross-examined. So that's point number one. It sounds obvious, of course. It sounds obvious, but it's something that we must take note of. No cross-exam, no re-exam. Period. If the witness is not cross-examined, then there can never be a re-exam. And that is why the advice always is, in the course of doing your examination in chief, you must get your witness to say everything that you need them to say as far as their contribution to completing the jigsaw puzzle is concerned. You cannot quietly say in your mind as you do your exam in chief, this question, let me leave it for now. I will ask it during re-exam. What if there is no cross-exam at all anyway? Then when are you going to ever ask it? Sorry, it won't happen. So, no cross-exam, no re-exam. Point number 2, Section 146(3) of the Evidence Act is telling us that the re-examination shall, has to be noted, shall be directed to the explanation of matters raised during cross-exam. Now that's an important point to note in terms of the scope of re-exam. Re-exam has a very, very narrow scope, as opposed to cross-exam, which we discussed the other day. We said that under 146(2), cross-examination is not confined to the matters that the witness was asked during examination in chief. That the cross-examiner has the widest possible spectrum to operate in. So long as it is relevant, the cross-examiner can ask it, even if it was not raised during the examination in chief. Very wide scope for the cross-examiner there. But now, when we come to re-exam, the story changes. The story changes in that we are being told that the scope of re-exam is only explanation of matters raised by the cross-examination. You see? And this is precisely the reason why the law is giving you, as the party calling this witness, a second bite at the cherry. Why are we getting this second bite? It is because the cross-exam may raise something that you did not deal with during the exam in chief. Therefore, the law now is giving you this opportunity to re-examine on those points raised by the cross-exam. And even then, it is not everything. It is not everything raised by the cross-exam that will then require some sort of re-examination. No. The firm has correctly suggested to us, point number 3, that re-exam is completely optional. Re-exam is optional. So that it is not something you do merely because the law gives you the right to do it. You do it only if there is need to do it. And if you read the textbooks, you will find authors saying that there are two situations that you may decide not to re-examine at all. One, where the cross-exam has done zero damage to the witness, either in terms of the testimony of the witness or in terms of the credibility of the witness. Not shaken at all. Or perhaps there are several parties to the case. The cross-examination did not touch upon your client at all, the fourth accused person. Whatever they were asked in cross-exam had absolutely no bearing to your client, accused person number 4. Therefore, no need to re-examine that witness at all. Now, you must remember the other day, this story I was giving you about this accused person who is not represented by counsel in a case of assault. And the doctor comes to testify for the prosecution. And when the accused is asked to cross-examine the doctor, what they do is not really a cross-exam. It's wewe daktari unanijua, wewe unajua ile kazi mimi ninafanya, unajua ninaishi wapi, ulikuwapo hiyo kitendo kikifanyika. Now, if that is the kind of cross-exam that the accused person has done, you as the prosecutor, are you going to be re-examining that accused person? No. Absolutely not. Because that is not a cross-exam anyway. It has not done anything to address the testimony of the good doctor, which is simply about the injuries sustained by the complainant. That's all. So you're not going to waste everybody's time by purporting to do a re-exam. You're doing a re-exam for what purpose? Zero. So that's number one, that you can decide not to do a re-exam at all if the cross-examination has not caused any harm at all, either to the testimony of your witness or to the credibility of the witness himself. And that is why it is very important, of course, it is very important at the time of cross-examination to pay very keen attention to what your witness is being asked by the cross-examiner. Very important, because at the end of the cross-exam, you must then make this call. You must make this decision. Do I require to re-examine this witness at all? You see, re-examination is not something that decide upon as part of your pre-trial preparation. No. In pre-trial preparation, you prepare for two things: examination in chief and cross-examination. That's all. Nobody prepares for a re-exam. As a matter of fact, and we made this point when we discussed examination in chief. At the time you're doing your exam in chief, you, apart from asking your witness everything relevant to their part of the story, you should also anticipate what they are likely to be asked by the cross-examiner, and in fact, get your witness to explain those bad facts in advance. In the course of your exam in chief, let your witness deal with the bad facts. So, if the cross-exam has not done any harm at all to the witness, you can choose not to re-examine at all. Now, the second one is the more difficult decision to make, which is that where the cross-exam has been so damaging that no amount of re-exam can undo that damage, one may also choose not to re-examine. If you consider that any attempt at re-exam can only exacerbate the damage already done. This one is difficult. I must admit, it's very difficult to make that kind of decision. And there is no formula that anybody can prescribe and say, well, this is how to make this determination, that no need to re-examine because my witness has been so badly damaged. Every case depends on its own merits. So, if you think that your witness has been exposed so badly as this terrible liar, just coming here to mislead everyone, you may choose to let the chiefs lie where they may and not do any re-exam at all. It's a difficult decision to make, I must admit. The first one is the easier one, where no harm has been done. All right? Because in reality, a good re-exam can actually do quite a bit of repair. It can do quite a bit of repair of the damage caused by the cross-examination. You see, the thing is this. Why do we have these three steps of examining witnesses? Why? Examine chief, cross-exam, then re-exam. So why do we have the re-exam part? It is precisely because the cross-examiner may, number one, introduce some new dimension about the whole story. Number two, the cross-examiner may deliberately say things to the witness with the sole aim of distorting facts, either by asking some irrelevant things, or by deliberately, as we preached last time, by deliberately stopping the witness from explaining something. So that in re-exam, now, this is your opportunity to complete this story. You remember when we kept preaching that in cross-exam, as soon as you get what you want for your closing, you stop. As soon as you get what you want for your closing, you stop. And even and we kept on saying, never ask the witness to explain anything. Never ask the why question in cross-exam. Now, we also say that if the witness attempts to explain something, to go beyond what you have asked them, you can, in a very subtle way, without being rude, without being disrespectful, you can stop the witness. Say, witness, you have answered my question. Let's go to something else. Now, in re-exam, the re-examiner will be saying, Mr. Smith, lawyer Otieno asked you this, and your answer was this. And when you tried to explain, he stopped you. Now tell the court, why did you do this? Why did you why didn't you pay? Why? It is the opportunity now for the witness to complete the story. You see, it's like magic, isn't it? So that at the end of the day, the court has the benefit of the entire story. I know it sounds crazy, but these are the things we inherited from the British. These are the storytelling rules that they brought to us here. Are they very good? Are they very nice for achieving justice? That is a story for another day, not today. So you can do a research and write a paper saying all these 3 steps of examining witnesses are nonsense. Why can't we do the inquisitorial judicial system? You can have that conversation elsewhere, and that is okay. You see, there are critics who write things all over the place saying that the law teacher in post-colonial Africa does nothing but regurgitate the things that the colonialists brought here 100 years ago. Well, the critic is right, but he is also wrong. We keep changing our laws all the time to improve things. But the law teacher teaches 2 things, 3 things. 1, this is the history of this idea. It's how it came about. 2, this is what the concept says today. 3, as social engineers, this is how we can improve this idea for the future. So the law teacher must teach what the rule says today. Of course, he can go ahead and critique that rule and say, well, this is rubbish. So anyhow, for the time being, what are we saying? That the reason why re-examination exists is because of the cross-exam, and the fact that the cross-exam potentially can bring in new material or can deliberately be designed to distort facts so that the re-exam serves to provide an explanation. Explanation. That's what the law is saying. And in doing so, you can do three things actually. The firm suggested two, but authors talk of three. This explanation that you are doing with your re-exam can be a salvage, a clarification, and a massacre. Now, massacre, don't get me wrong. We are not cutting anybody's throat. We are only asking a question or two to hammer the last nail on the coffin. Basically, to re-emphasize, where absolutely necessary. Like that question to Alphonse Mwoki, you will have asked it in your exam in chief, that why did you let faith live on your land all this long? Yes, you will have asked it, and an answer will have been given. The cross-examiner, when his lawyer, no doubt, will ask the same thing in a cross-exam. Now, in your re-exam, there is no harm at all in saying to the witness, Mr. Mwoki, please remind this court one more time. Why did you allow faith to stay on your land? That is called a what? A massacre. To just hammer on the point one more time. One more time on a very good fact of your case. All right? Although, of course, the most common aims of re-exam is to salvage and to clarify things that the cross-examiner, deliberately or otherwise, sometimes the bad things in the cross-exam may be inadvertent because of a very poor cross-exam. All right? So, the re-exam can be very useful in that respect, to salvage, to clarify something. But we emphasize that the scope of it is very narrow. Only matters that were raised during cross-exam. It is not the opportunity, mark you, it is not the opportunity to repeat the entire exam in chief, which you already did earlier on. Number two, it is not the opportunity to repeat the cross-exam once more. You see, re-exam can be very risky, and the firm has alluded to this point. It can be very risky when your re-exam serves to re-emphasize a bad fact of your case that has already been very thoroughly dealt with by the cross-examiner. So you can do further harm to your witness by doing a poor re-exam. You see? So those are two don'ts to be careful about them. Don't repeat your entire exam in chief. What for? The court has already recorded that. Don't repeat the entire cross-exam. What for? Rather, focus on explanation of those things that the cross-examiner deliberately or inadvertently left out or distorted. Now, there is a small proviso in 163, section 146.3. Not a proviso in the traditional sense, but if you look at that paragraph, you will see the first part is saying that the re-examination shall be directed to the explanation of matters raised in the cross-exam. Then there is a semicolon. The paragraph continues to say, and where with the permission of the court, new matter is introduced in the re-examination, then the other party may further cross-examine on it. Now, there is that other very small window. The firm did not emphasize on this point, but it's a useful point to make, that during re-exam, the law is giving us a very tiny window to introduce some new matter that was not introduced during exam in chief. Some new material, by which we mean new evidence, with the permission of the court. Now, what would justify this kind of application for leave to introduce something new? Why didn't you deal with it during exam in chief anyway? So, we want to emphasize that this is a very, very narrow window. Very narrow. The circumstances where you may make such an application are so rare, because it must be something arising out of the cross-examination. Number one. Number two, even where it arose from the cross-exam, it is not obvious that if you make this application, the court will permit it. The court will only permit it if A, it was raised for the first time during the cross-exam, B, it is something that is necessary to counter this allegation made in the cross-exam, and it was not a fact in issue ab initio, so that then you would have needed to deal with it during your exam in chief. Let me give an example here. You have filed a suit by way of a plaint, say arising out of a road accident. So you're seeking compensation on behalf of your client. Now, in your plaint, obviously, you have alleged that the first defendant was at all material times the registered owner of motor vehicle registration number this. In the defense, as we always do, the defendant, first defendant, has denied. They always deny, even when the truth is otherwise. So the first defendant denies having been the registered owner of the subject motor vehicle at the material time or at all. So that's a defense that has been served upon you. Now, immediately, the question of ownership of that motor vehicle becomes a fact in issue in terms of Section 5 of the Evidence Act. And therefore, it will be incumbent upon you as a plaintiff's lawyer, when you do your case, to adduce evidence to show that, in fact, the first defendant was the registered owner of that motor vehicle. And so you must go to NTSA, do a search, and you have a copy of records showing that on this date, the date of the accident, the registered owner of the motor vehicle was X. He who alleges proves. The moment I deny it, you must prove it, even if I'm denying just for fun. Now, supposing due to inadvertence, negligence, or incompetence, whatever, you as the plaintiff's lawyer, as you do your case, you don't adduce that evidence. You don't adduce it. And in the cross-examination, the defendant's lawyer comes and says to your witness, the plaintiff, witness, in your plaint, you claimed that my client X was the owner of this vehicle on the date of the accident. Yes. The defendant, in their defense, paragraph 3, denied being the owner of the vehicle. And you know, it doesn't matter whether your client ever saw the defense or not. Whether you give them to read or it doesn't matter. It's their case. It's not the lawyer's case. So then the lawyer goes on and says, this was denied. Yes. You did not produce any evidence to show that my client was the registered owner of the vehicle. Hiyo nilikuwa nimewachia wakili. That's the answer they will give. Now, you as at the end of the cross-exam, you as the plaintiff's lawyer, you now stand up. Your Honor, under Section 146(3), I'm applying for leave to introduce a copy of records of, of the ownership. Your Honor, this is not in dispute. The application will be denied. Hello? The court will reject that application. Why? That was always a fact in issue that you should have dealt with right from the word go. You made the allegation in the plaint, it was denied in the defense. So, the cross-exam has not introduced anything new. You see? Now, question. What sort of situation then might justify the use of this very narrow window that we are talking about here? Again, I have a typical example. I don't invent any new ones. Why should I trouble my mind when I'm tafuta zingine? If, say, in the cross-exam, this same case that we were doing, same accident case, as part of the cross-examination, the lawyer there refers to a judgment of the magistrate's court showing that the driver of this vehicle, defendant number 2, was actually convicted of a traffic offense arising out of that accident by the magistrate's court after a trial. Was found guilty and fined. Now, turns out that, and you are aware as a plaintiff's lawyer, after this conviction, there was an appeal to the High Court, and that in the High Court, the appeal was successful, and the conviction in the court below was quashed. Now, the cross-examiner did not refer to that, deliberately or otherwise. We don't know why. Maybe was not aware of the appeal, or even if they were, they decided to ignore it anyway. In a situation like that, you could then make an application to the court saying, Your Honor, we have a judgment from the court, the High Court, where this conviction was quashed. I apply for leave under Section 146(3) to introduce this High Court judgment to counter the material on conviction that was brought in by the cross-examiner. In a situation like that, you see now, in the pleadings, those allegations were not there about the traffic case and then somebody being convicted. Those things were not there because maybe at the time this civil suit was filed, maybe the traffic case was still pending and going on in the traffic court. You see? So that, if you ask me, is one, simple example of a situation where one could make an application under that proviso to, section 146(3) of the Evidence Act. Okay? It's a very narrow window. That's why we are emphasizing that when you do your exam in chief with all your witnesses, you must ensure that you tell the whole story. Don't leave anything hanging in the hope that the cross-examiner will not deal with it or that you will deal with it during re-exam. No. Deal with the entire story. Let every witness complete their piece of the jigsaw puzzle so that at the end of it all, the court has the benefit of a complete picture of what actually transpired. So you can see, good people, that when we were doing cross-exam, an impression may have emerged that cross-exam is about misleading the court, is about withholding information, is about, these are our storytelling rules. And the re-exam is the opportunity to correct all those distortions. Even where we did this thing we called impeachment, you may have done what you consider to be a very good impeachment of a certain witness. In the witness statement that the fellow recorded with the police after the incident, it is written there that the incident happened at 2 p.m. In court, the fellow says it was at 4 p.m. And so, as a cross-examiner, you have hammered on that point in doing your purported impeachment. And at that point, it looks very nice. It looks very like a serious contradiction. Serious contradiction. I mean, 2 p.m. and 4 p.m., this fellow surely could. In the re-exam, it is possible for you to demonstrate that, look, witness, in your statement you said 2 p.m. In court, you have said 4 p.m. Why? You see, the cross-examiner will not ask the why question. Do you know what the witness will say in re-exam? Mheshimiwa, mimi nilipeana statement yangu kwa Kiswahili, niliambia polisi ilikuwa masaa ya saa 8. Saa 8. Mheshimiwa, saa 8 kwa lugha yangu inamaanisha afternoon. Afternoon ikio kyote. Kuanzia saa 8 mpaka 5 uko yote. Hiyo tunaitanga saa 8. Hiyo ni masaa ya saa 8. And the whole thing is explained. You see, it was a seeming contradiction when the impeachment was done. It appeared like a serious a contradiction, isn't it? I mean, a difference of 2 hours is substantial. But you see, the policeman was recording, when you say saa nane, the policeman say, ilikuwa masaa ya saa nane. So the policeman records 2 p.m. You see? And the policeman is right, because he's recording in English, but you're speaking in Kiswahili. So you can see the point we're making here, that a re-exam can be very, very useful to correct some of these apparent, distortions, seeming inconsistencies. We are calling them seeming because they were not real as such. Okay? One last useful point I would make is this, and I think the firm suggested this one without proper emphasis, that at the end of the cross-exam, if you consider that you need to take further instructions because of certain things that the cross-exam has raised and which were not dealt with in the exam in chief, it is okay to ask for an adjournment before proceeding with your re-exam. All right? Depending on how serious the issue is, you can ask for a couple of minutes, you can ask for 20 minutes, you can even ask for adjournment to another day. Maybe you need to go and fetch some material from somewhere to counter a certain allegation that has been made by the cross-examiner. So it is, so long as you establish a basis for your application, so long as you establish a basis that, look, the reason you're asking for this adjournment is for you to get further instructions, or from your client, or to consult this particular witness on a certain point before proceeding with the re-exam. That is okay, right? So although we are saying that ideally, and in most cases, the re-exam takes place immediately after the cross-exam, that need not be the case all the time. If you consider that there is need to take further instructions on some point raised by the cross-exam, I insist, on some new point raised by the cross-exam, then it is okay to ask the court for a brief adjournment, or even to another day, to enable you to take further instructions from your client, or to consult the specific witness before proceeding with the re-exam. Finally, we go back to Section 150 of the Evidence Act, which is re-exam. The form of questions is exactly as in exam in chief. So this is your witness. Therefore, we go back to one fact, non-leading questions. All right? So we go back to, now we leave the leading questions in cross-exam. We go back to Section 150 of the Evidence Act, that all our questions in re-exam must be one fact, non-leading questions. That's the law. Forget about those little exceptions which I told you the other day to forget about. They don't add any value really to the whole business. Indeed, as I've already suggested, the most important question in re-exam is the why question. The why question. All right? So you the preface of your question is what the witness was asked in cross-exam. So, witness, lawyer, so-and-so asked you this, and your answer was this. Why did you not pay in time? Why did you reject the goods? Why did you, the why question is perhaps the most crucial question in re-exam.